courts, a judge should not hear a matter if the judge has an actual conflict of interest or if it appears that the court might have a conflict with a particular case. Without getting into all the details right now, the judge indicated previously that he has a knowledge of Mr. Shabazz from working with Mr. Shabazz in the community. He reiterated that today and expanded on that somewhat in terms of his memory of their working together. In that context, and given that one element of this case, as you all know, is entrapment, and one element of entrapment is someone's history, and whether they have a proclivity or tendency or a history of engaging in certain activities, or, to the contrary, they do not have that history and were entrapped into that behavior by some federal or state agent. Given that that's a cardinal element of the defense, the nature of Mr. Shabazz's involvement in this community over many years becomes relevant. And the judge, as he's indicated, has direct personal knowledge of that, for good or for bad. But he has direct personal knowledge of it. And in that sense, that he says he could be fair and impartial, and as I said in court, I'm not doubting whether he can or not. He knows that better than I know it. But there's an appearance, given what he said, that perhaps that personal knowledge could influence the proceeding or would appear to influence the proceeding. And that is not something that should be, under the rules, allowed. So that's where we are right now. We have a couple of weeks to make a written application to the judge explaining our thinking. People have a week to respond. The judge will then decide whether to retain the case and deny recusal or to recuse himself. And that, again, is his decision in the first instance. It's not anyone else's decision. He has to search his conscience and the facts as they're provided and make a determination as to what he ought to do. And I don't think there's any more that needs to be said other than Mr. Shabazz has indicated to me, without getting into detail, that he feels that the prior history between them could create an appearance of impropriety, and therefore he feels it would be best to have a judge who does not know him and is therefore looking at this simply based on what's in the record of the case, which is what a court is supposed to do. And again, I don't want this to be construed as slamming Judge Williams. It's not intended to be that. It's intended to uphold the systemic integrity that we have here and are supposed to have here. Okay, I hope that's clear to everyone. And as you heard, we're supposed to be back here, if at all, on October 9th at 11 o'clock. The judge is going to render a decision or hear arguments.
Michael, can you speak at all to the motion to limit discovery?
I can't speak to it other than that we're vigorously opposing it. My associate, John Connell, who's standing next to me, wrote an excellent submission to the court explaining to the court why the effort to limit the discovery is improper. Certainly we need all the discovery in order to assess the case. It's all material that under the rules both of this court and the state and the federal constitution we're entitled to. And we are arguing strenuously for it. We actually thought the judge might want to consider that today, but the judge at the district attorney's suggestion deferred doing that until the recusal motion is resolved.
Mr. Shuster, in the event that the judge denies the application to remove himself, is there another alternative course of action?
You're saying the possible appeal?
Appeal, yes.
Yeah. As in many other matters, there are what are called interlocutory appeals, which means an appeal while the case is pending. But we'll cross that bridge when we come to it. We'll see the reasoning. If the judge does deny the application, what his reasoning is, and we'll make a decision whether we wish to take an appeal. I don't want to commit to that yet because it's not responsible until we see what he says.
When the judge said something about he thought that maybe they wouldn't have to appear today, what do you think he was referring to?
Being unprepared.
Oh, you're talking about the other lawyers, the prosecution?
No, the judge himself said that because something about the DA, he expected the DA to tell them that they didn't have to appear. Was that because he thought they were going to be unprepared? Is that what he...
No. It's a little bit complicated, but basically what's going on, again, without speculating, is that the district attorney's office made what it fashioned.
Louder, please.
The district attorney's office made what it fashioned was an ex parte application. An ex parte application means an application made to the judge without notice to the other side and without the other side having an opportunity to be heard. That's what ex parte means in the law. But when they made an ex parte application here, they served it on us. You understand what I mean? They gave us a copy of it, contemporaneously with giving it to the judge, I believe.
I don't know if it was contemporaneous, but we got it with discovery.
We got it quickly. So when we got it, again, after conferring with Ishmael, we decided that we needed to oppose it. And we opposed it, having gotten it. So I think the judge was simply pointing out the kind of incongruity there was with someone filing that kind of application and also giving us the, and then, you know, we responded, and I don't think the judge was critical of our response. I mean, the fact that we responded, I think he thought that's what you do. You got it. He was just a little surprised that they did this paradoxical thing. All right? Yes, ma'am?
Do you find it ironic that the next hearing date is the day before the Million Man March? You know, we're not talking about that type of thing, but I'm just saying, you know, there is a march going on for our black people, and it happened to be the day before the march. So we will just have more support here the day before the march. It won't take away from our attendance. It'll actually help us grow. So do you tell them to prepare for a bigger courtroom?
Well, the judge indicated at the bench that this proceeding on the 9th, if it's held, would be held in the larger courtroom. He actually said that right at the bench.
What's the maximum capacity number of people?
Well, there had to be room for
120, 200.
So 200.
No.
When I
Should
counted,
be posted.
44 attended.
No.
42
The question is how
today.
many, what's the capacity of the room upstairs?
For the audience.
Well, what's left out of what we took up?
No, we don't know. We need numbers. I don't know what
Let's
we
say
took up.
120 to 200.
120 to 200. Okay. So
All right.
can you, okay.
We'll find out.
Mr. Shabazz will let everyone know that, and you'll, I mean, I think it's incredibly important, as the judge himself said, that everyone come to court who wants to know directly what's going on. Because, you know, we all know the old game of telephone, and we read it every day in the newspaper. You know, if you're at an event and you see how it's reported, I'm involved in many cases that are in the newspaper. You barely can recognize it. Without no disrespect to the press, that's just the way it goes down. So I think for people to directly come, obviously if you have time and can do it, to make time, it's important. And it's important for the whole system, not just the court, but everyone, including the district attorney's office, to see there are people who care about this and are not convinced by the pretrial publicity that this man did anything, okay, of a criminal nature. So let's stay together. And I'm sorry more didn't happen, but I think this is a necessary step.
Absolutely.
All right?
I just say one thing. I just want to say I thank everybody for coming. But what's important, man, is that when you're in the courtroom, please don't say anything. Because while we have this judge, I mean, I don't know what happened this morning. You know, I guess it was too many people that he expected. So he's not used to that. So, you know, he'll get an attitude like that. He'll take it out on us. So please, man, just be respectful of this. You know, we'll talk when we come outside. But thank you again.
Can you tell us what in particular they're trying to suppress? It's part of the
Sure. There are allegedly, and again, since we haven't seen them, I'm using the word allegedly, because I don't know what's in them, I haven't seen them. There are allegedly audios and videos of contacts, I'm assuming, between Mr. Shabazz and individuals who've been one identified as an agent and one identified as an informant, as I understand how these two people are being identified. And I don't know, to answer your question, I don't know what's in it other than them interacting in whatever way they interacted with Mr. Shabazz and whatever other interactions they engaged in that may be pertinent to the case. And obviously that's of some importance to the defense in the case and to everyone else. Well, what happened between all these people? And well, we have Mr. Shabazz's own account. We need to see what they've got. Right?
And am I correct? I'm sorry, Patricia Doxey with the Daily Tribune. Am I correct that the prosecution is attempting to not be required to turn that over to you?
Right. They're certainly. They very clearly don't want to turn it over to us. They have indicated they don't even want us, though, to see it. at this point, pre-trial, which is what's particularly extraordinary and unusual. And if we ever could see it, to see it in their offices, which again is not a satisfactory solution, because obviously any defense lawyer in any case involving video or audio evidence is going to want to meet with the client in the privacy of their own office to go over with the client so they can have a candid conversation, whatever it is. And you can't really do that in the district attorney's office. It's kind of the, not the place to do that. So that's one of the other issues here. If we get it, where do we get it? And do we have it? And do they trust us enough, or do they think that as soon as I get it, I'm putting it on YouTube or something, which really isn't my interest. I am prepared to try a case in the court. I think that's our system. It's very important that you come. It's very important you hear what you hear, but it's also important that we respect the idea that there's a trial. Mr. Cartwright did not respect that idea because he tried publicly to besmirch Mr. Shabazz right from the beginning. And now, of course, having done that, he doesn't want to give us access to information. So, this is...
My final question is the limiting of discovery. Have they given the justification for that? Is it to protect?
It is supposedly to protect people who they've already publicly identified, and who everybody knows who've been identified. And this is part of what Mr. Paul will write in the response, that the cat's kind of out of the bag already. Who are we protecting? I mean,
is that why he kind of fumbled when she asked if the newspaper can record it, stuff like that?
I can't answer why he fumbled. I mean, I think their position is a little silly because they're not, as the judge said, they're not trying to close the courtroom. They're not trying to keep you out or the press out. Once you're there, you can report whatever goes on, and whether you have a video or audio of it, what's the difference, honestly? Just to let more people know what actually happened, which I think is an important value, nothing diminishing the system. All right, I hope that answers your questions, and thank you all for coming. Have a good day.
I don't know where
Somebody give Michelle a ride home before he left.
Much better.